Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the Willful FBAR penalty. The Willful FBAR penalty is a little more complicated because there's a bunch of horrendous fear-mongering and scaremongering online, individuals being told that they're automatically going to go to prison if they don't pay an exorbitant fee to some attorney to avoid prison. It just doesn't really work that way. So why don't we walk through the basics and try to ease your mind a bit, give you an idea of how the process works. Excuse me. From a baseline perspective, the FBAR is a foreign bank account reporting form. It's used to report foreign bank and financial accounts, bank accounts, investment accounts, savings accounts, foreign life insurance, pension accounts, etc. Hyper-technically, if you see the term FinCEN Form 114, that's the technical name of the form. FinCEN refers to the Financial Crime Enforcement Network. It rarely has anything to do with crime. It's just the unfortunate name of the organization. The FBAR is filed at the same time your tax returns are filed. If you file for an extension, your FBAR automatically goes on extension as well. At the current time, you don't need to apply for a separate extension for the FBAR. FBAR is filed by lots of different persons. Corporations and businesses are considered persons, trusts and estates. When it comes to individuals, there's three main categories. That is U.S. citizens, legal permanent residents, and generally visa holders or non-residents who meet the substantial presence test. Typical visa holders that we see who may not be aware: H-1B, L-1, E-2, E-3, O visa, EB-5, etc. The Willful FBAR penalty. Now, what makes willfulness complicated in the FBAR arena is that it's nonsensical. The IRS doesn't use the common sense phraseology of willful as an intent in order to describe the willful penalty. Instead, you can be considered willful even if you're unintentional, you're non-intentional. Let me give you an example. You could be willfully blind, which means you don't have any actual knowledge, or you could act with reckless disregard, which means you don't have any intent. Even if you have a lower level of willfulness, the IRS still hits you with the same penalty, so it doesn't lower the penalty. The penalty currently is 50% on the maximum balance. Over a multi-year period, it can't exceed 100% value on the account. It used to be 300%, now it's 100%. The 300% comes from the fact that it was 50% per year for up to 6 years. If you're below that amount, the IRS can still hit you with a $100,000 minimum penalty per year. It's basically a floor, so it's $100,000, 50%, whatever's higher. There's been some dispute regarding a prior regulation and the interpretation, etc., etc. Most courts have come in favor of the IRS. When it comes to a willful FBAR penalty, the other concern is that it could lead to more complicated issues such as tax fraud, possible criminal investigation. With the IRS special agent's practice pointer, if the special agent, they normally travel in pairs. If they ever knock on your door, you kindly tell them you want to speak to your attorney. Don't have any direct communication with them. When it comes to civil willfulness, the IRS has to show, or not the IRS, the Department of Justice, whichever agency is coming after you, has to prove intent. So it's not as simple as in with the civil willful. They just have to show facts that could lead to potential willfulness, including reckless disregard and willful blindness. The $100,000 that's mentioned in the statute, it adjusts with inflation, so that amount may go up each year. Even though it's willful, potentially it can still be mitigated. There is no bright line test, so it's a totality of the circumstances. Depending on which agent you get, which firm you're using, you may be able to possibly get the maximum penalty reduced. Remember, it's 50% max value, but there is room for mitigation. In order to avoid these penalties, you typically want to submit to one of the amnesty programs. And if you're willful, unfortunately, the only amnesty program available is the traditional voluntary disclosure. There used to be something called OVDP, A lot of other practitioners who don't really specialize in this area of law would kind of talk bad about it. It's a 27.5% penalty. The problem is under the new program, it goes by the Internal Revenue Manual, and the Internal Revenue Manual says it's 50% absent mitigating circumstances. With the program, there are some benefits that weren't available under OVDP. If the majority of your other penalties are informational returns for businesses and corporations and things like that, you may be able to avoid penalties on that. There is no closure the same way there is with OVDP, but if you're willful, it's the best way, one, to get into compliance, regain your peace of mind. It's generally limited to 150% penalty, if not less, if you can mitigate it, versus if you just get hit with penalties, it could go up to 100% if it's a multi-year situation. That's an introduction to Willful FBAR Penalties. My name is Sean Golding with Golding & Golding. If you want some additional information, please visit our website at goldinglawyers.com. Thank you very much.